Hello, this is Tony Jenkins, and welcome to this eCPD module which deals with a general tax case update and provides an overview of recent important tax cases. Completing this module on tax cases will enable you to identify the facts, the decision and the implications of a case involving IR35 and BBC presenters. It will enable you to understand the facts, decision and implication of a case looking at the nature of a capital gains tax disposal. It will enable you to consider the facts, decision and implications of a case involving entrepreneurs' relief and preference shares. And finally, understand the facts, decision and implications of a case looking at the definition of potential lost revenue. Throughout most of the calendar year, there are cases being heard by the various levels of the courts, including the tribunal system. Some involve either historic tax law, which has been subsequently amended, or complex or obscure legislation. Other cases can be of very wide-ranging application. These cases can come from the different levels of the court system. Those included in this update come from the first-tier tribunal and the upper tribunal. This module looks in detail at some of the important cases from different tax perspectives in the last few months. The four cases that we are going to be looking at are, first, Pyre Limited, Tim Wilcox Limited, All Day Media Limited versus HMRC. Second, the Leeds Cricket, Football and Athletic Company Limited versus HMRC. Thirdly, Stephen Warshaw versus HMRC. And finally, HMRC versus James Robertson in the upper tribunal. The three cases previously mentioned were all in the first-tier tribunal. Let's look at the facts in the first case relating to IR35 and BBC presenters. Three BBC presenters, Joanna Gosling, Tim Wilcox and David Eads, referred to as G, W and E, each operated personal services companies or PSCs, Pyre Limited, Tim Wilcox Limited and All Day Media Limited, providing their respective services to the BBC. The PSCs were set up during 2003 and 2004. Each of the presenters had worked for the BBC for a number of years previously. In the period from their establishment until 2014, the PSCs entered into a series of contracts with the BBC for the provision of the relevant presenters' services to the BBC News Channel, referred to as News, and/or the BBC World Channel, referred to as World. News and World provided live coverage of news events in the UK and around the world. The presenters all did some other non-BBC work, although not as news presenters and to varying degrees. In 2014, the presenters were all engaged directly by the BBC under continuing contracts, which the BBC treated as employment contracts for tax purposes. HMRC challenged the companies, arguing that the presenters' earnings for 2006-2007 to 2013-2014 were caught by the IR35 rules, making the companies responsible for tax and national insurance on those earnings. The appeal followed the usual format of such cases, whereby the tribunal looked at mutuality, control, and other provisions within the contracts to see if they were consistent with them being contracts of service. Now, let's look at the decision. The first-tier tribunal decided that the BBC was aiming to shift the employment tax risk to the presenters through their personal service companies. Judge Morgan concluded that IR35 applied to most of the contracts. She considered mutuality of obligation and control in detail. See further in the notes. Judge Perrin agreed with the finding of the facts, but disagreed with the final conclusion reached by Judge Morgan. The final decision rested with Judge Morgan's casting vote, with the final decision going in HMRC's favour. However, the judges agreed that the presenters and their advisers had acted in good faith, and had not been careless in their decision to disapply the IR35 rules. This meant that the inquiry period was limited to 4 years, and so some of the determinations were invalid as they were issued out of time. Now let's examine the practical implications from this case. On a split decision, the work done by 3 BBC presenters was held to fall foul of the IR35 rules, so tax and national insurance contributions were due on payments made to them by their personal service companies. If these presenters had been investigated today, the new off-payroll rules in Chapter 10 of ITPA 2003 would apply and would have resulted in the BBC picking up the bill. The decision in HMRC's favour seems to give weight to 1. The relative longevity of the arrangements, in effect continuously over the 5 and 7 years under appeal. 2. The control test could be satisfied by finding a sufficient framework of control, thus referring more to overall control. And 3, there was no sense in which the presenters were in business on their own account, i.e. self-employed. The second case involves examination of the nature of a disposal for capital gains tax. Let's look at the facts in this case. The Leeds Cricket, Footballer and Athletic Company, otherwise referred to as LCFA, owned the freehold of the Headingley Cricket Ground, the property which it leased to Yorkshire County Cricket Club, or YCCC, whilst retaining the right to carry on hospitality, catering and advertising. On the 30th of December 2005, LCFA entered into a contract with YCCC for the sale of the property. The contract provided for the sale of the property and goodwill. Goodwill was defined as the business carried on at the property, including the letting of advertising boards and the provision of hospitality and catering services, overall referred to as the cricket business, but excluding the hotel business and rugby activities. The catering business was licensed back to LCFA for an annual fee. Although the ground prior to the sale was leased to YCCC, LCFA maintained the right to carry out hospitality, catering and advertising in the ground. This included selling corporate hospitality packages, selling advertising on the boards around the ground, and providing meals and refreshment to visitors to the stadium on cricket days. The case called these activities the cricket business. On the sale of the ground to YCCC, LCFA provided details of customer lists and transferred third-party arrangements to YCCC, and the catering business was licensed back by YCCC to LCFA. The question before the tribunal was whether the sale was a disposal of 1. Land with attached income streams that would be treated as a capital gain, or business with attached goodwill. Let's look at the decision. A business was being carried on prior to the transfer because the activities carried out by LCFA in running the various operations meant that it was not simply a passive income stream as argued or contended by HMRC. The fact that the operations were ancillary to ownership of the property did not mean that a business was not being conducted. There was goodwill attached to the business because the tribunal was satisfied that this had been generated over the years by hard work and that there was an established client base and reputation. The goodwill was not subsumed into the value of the property, firstly because it was not necessary to distinguish between inherent or site goodwill and adherent or free goodwill, and second because the evidence demonstrated that the cricket business could have been sold and carried on elsewhere. A business was transferred and goodwill was included in the transfer. The terms of the contract showed that goodwill had been assigned, and the tribunal rejected HMRC's arguments that LCFA was carrying on the catering business both before and after the sale, because this ignored the existence of the licensing arrangement. Because LCFA had engaged a third party to sell the hospitality packages, it was not carrying on the hospitality operation because in their view outsourcing was part of running an efficient business. The tribunal concluded that a business had been transferred because what was transferred was sufficient to put the transferee in possession of a going concern. Let's look at the practical implications from this case. The key to this decision was determining the true nature of what was being disposed of, as it was central to the tax treatment. The tribunal did not accept HMRC's principal argument that there was no goodwill capable of transfer because there was no business to which it could be attached, and that LCFA's income from operations was primarily derived from the land. As rollover relief requires the asset disposed of to have been used for the purposes of the trade, TCGA 1992, Section 152, Subsection 1, it seems strange that the focus was on the meaning of business rather than on the meaning of trade. The third case looks at the important relief of entrepreneurs' relief and what quantifies or qualifies as ordinary share capital. Stephen Warshaw, SW, was chairman of Cambridge Educational Group Limited. Prior to 12th of March 2012, he held 44,183 ordinary shares and 396,000 preference shares in Cambridge Education Group Limited. Following a group reorganisation in March 2012, SW exchanged these old shares for new shares in a new company, Cambridge Education Holdings Jersey Limited. On the 26th of March 2012, SW subscribed for 24,660 B ordinary shares in the new company and became a director on the 26th of October 2012. On the 4th of December 2013, SW disposed of his entire shareholding for cash and ceased to be a director from that date. On the 28th of January 2015, he submitted his 2013-2014 self-assessment tax return, including a capital gains computation for the disposal of the shares totalling £6,438,419 and a claim for entrepreneurs' relief in respect of the disposal. On the 5th of October 2015, HMRC opened an inquiry into the return, and August 2017 issued a closure notice denying the entrepreneur's relief claim. Continuing from the previous slide, the rights attaching to the various classes of shares in the new company were set out in its Articles of Association. The preference shares were cumulative. If there was insufficient reserves to pay the dividends in respect of those shares in a particular year, payment was deferred to a subsequent year. This meant that the rate at which the dividend would be paid, 10%, would be calculated as the aggregate of the subscription price and the total unpaid dividends. The issue was how the preference shares were to be treated. In summary, if the preference shares were ordinary share capital, SW held 5.777%. However, if the preference shares were not ordinary share capital, he held only 3.5%. Let's look at the decision. The first-tier tribunal agreed with the taxpayer that the decision of Judge Vinalot in Tilcon v. Holland offered some support. In reaching their decision, they must take into account both the percentage element and the amount to which that percentage is applied. Under the Articles of Association, only the percentage element was fixed. The amount to which that fixed percentage was to be applied could vary. Consequently, the preference shares could not be regarded as having a right to a dividend at a fixed rate, and were therefore ordinary share capital as defined by Section 989 of ITA. The appeal was allowed. Let's consider the practical implications from this case. The first-tier tribunal held that a dividend payable at a specific or specified percentage on a base amount that could vary was not payable at a fixed rate. Hence, the shares on which it was payable were ordinary share capital. Cumulative preference shares represented part of a shareholder's ordinary share capital for the purposes of entrepreneur's relief. Since entrepreneur's relief was introduced in 2008, the majority of appeals have concerned the meaning of ordinary share capital for the purposes of the personal company definition. This case provides a further contribution to that debate. Because entrepreneur's relief represents such a valuable relief from capital gains tax, it is crucial that all the relevant conditions are met, and one of the most important is that of the relevant shareholding, as can be seen in this case. A similar issue was resolved in another case, Philip Hunt, TC 07057. The fourth and final case deals with the meaning of potential lost revenue. Prior to the introduction of the High Income Child Benefit Charge, or HICBC, in January 2013, Mr. Robertson was not required to notify his liability to tax to HMRC or to complete a self-assessment return, as his income was taxed wholly under PAYE with annual income exceeding $50,000. In 2012-2013 and 2013-2014 and 2014-2015, Mrs. Robertson received child benefit, but they did not elect to stop receiving the benefit. Under the HICBC legislation, Mr. Robertson should have notified HMRC of his liability to tax. HMRC decided that the HICBC applied and issued discovery assessments for the 3 years unpaid HICBC as well as penalties charged at 20% of potential lost revenue for failure to notify chargeability. Mr. Robertson appealed against the penalties, but not the assessments. The first tier tribunal concluded that there was no potential lost revenue and so no penalties could be charged. HMRC appealed to the upper tribunal. Let's look at the decision. HMRC conceded that the penalty should be charged at 10% of the potential lost revenue rather than 20%. The upper tribunal stated that potential lost revenue is defined under Schedule 41, Para 7 of the Finance Act 2008 as so much of any income tax to which P is liable in respect of the tax year as by reason of the failure to notify is unpaid on the 31st of January following the tax year. The first tier tribunal should have concluded that HMRC had calculated the potential lost revenue correctly based on the unpaid tax liability. Instead, it decided that potential lost revenue was limited to and determined by the tax shown in an assessment which was an error. Allowing HMRC's appeal, the judges upheld the penalties calculated at 10% of the potential lost revenue. Now let's look at the practical implications. Penalty provisions are important in tax legislation as they enforce taxpayers paying their liabilities. Penalty provisions need to be accurately drawn and easily comprehensible to ensure they achieve the intended objective. When penalties are raised in respect of an amount to be determined, as with potential lost revenue, clarity is required, and hence this matter came before the tribunal for decision and clarity. In summary, the key things to remember from this module are, with the case involving IR35 and BBC presenters, how the facts in each case are important and went in favour of HMRC. With regard to the case involving the nature of disposal, how the facts of this situation determined the nature of what was disposed of and the consequences thereof. With the case involving entrepreneurs' relief and preference shares, the continuing importance of the detailed rules in entrepreneurs' relief and what is defined as ordinary share capital, and finally the case involving potential lost revenue, the importance of determining the exact definitions of amounts when determining penalties. I trust that you have found this module, which is a general tax case update, informative. Goodbye and thank you for using Croner eCPD.
For further information and to view the full range of Croner eCPD modules, visit our website at croneri.co.uk.